I am former asylum officer and former immigration services officer, and also a former HUD trial attorney. And my name is Meron Muskol. I'm an attorney, and today we are going to be discussing, for those of you who have been referred to immigration court, and this is after having an asylum interview, so an affirmative asylum interview. So just keep in mind there is a new policy where currently it just started July of this year, 2026. I believe it's 26th through the 28th, and it's effective immediately where certain applicants who have applied for asylum affirmatively, so with the asylum office, may be directly referred to immigration court if they fall into specific categories. What I'm going to be discussing today is those of you who have had an interview and for whatever reason the asylum officer has referred your case to immigration court. So now you are at immigration court. This usually happens if you had no underlying status to fall back on. So, what I mean by that is, let's say you're an F1 student and you apply for affirmative asylum, and I'm just giving an example, you had the interview within a few months. So, you're still an F1 student. Generally, what would happen in that case is you would get a notice of intent to deny if that officer intends to deny your case, and you have an opportunity to respond. That is not what I'm talking about here. What I'm discussing here is someone who had an interview, maybe depending on how long it is, but regardless, they don't have an underlying status. So they're not currently an F1 student, they're not here on an H1B, nothing like that. They possibly came as a B2 visitor and they applied more than likely within a year of being here in the United States. And so now they just have this pending asylum case. If after the interview, for whatever reason, that asylum officer decides not to approve your case, it could be because that officer feels that you did not prove past persecution. It could be because that asylum officer did not find you credible, things like that. Then that officer may refer you to immigration court. So you'll usually also be getting an NTA. And what an NTA stands for is a notice to appear. Now, that notice to appear includes certain information about you. Generally, it'll include your name, your A number at the top right. I'm actually looking at one right here. Um, your full name, your address, and it'll have different categories, for example, and this is currently, so just know that this is subject to change, but it might have a few boxes where it clarifies or states you're an arriving alien or you're an alien present in the US who has not been admitted or paroled, or you have been admitted to the US but are removable for the reasons stated below. So one of those boxes might be checked, and then they'll usually have 4 to 5 numbered categories where the Department of Homeland Security is alleging something. So, for example, you are not a citizen of the US. Number two could be you're a native of this country, which is not the US. Um, it could be the date that you were admitted, and then it can include, for example, the date that status expired and you failed to leave the country, whatever the case may be. So there's 4 to 6 allegations. Um, and then it'll say on the basis of the foregoing, it's charged that you're subject to removal, and then it'll state a specific section of the law. At the very bottom, it will generally, and I say generally, include the court that you're subject to and the date that you're supposed to show up to court. Sometimes it might be to be determined where the date might not be there, but it lets you know that it's coming soon. So if you have a specific date, if you have a specific address for where you need to show up, you need to make sure that you show up. And I say that because if you do not attend a master individual hearing in immigration court and you have a scheduled date, then you can be issued an in absentia order, basically saying that, well, you here in removal court and you're supposed to be here, you didn't show up. And for that reason, the immigration judge might just give you an order of removability, basically saying you're removable because you met all these requirements and you have no underlying status. So make sure you show up to your hearing. Even if you don't have an attorney yet, you could possibly go there and explain, I need more time to find a lawyer. So when you do show up to that hearing, that first hearing is generally a master hearing. And I say generally, there are a few advisals that you need during this master hearing, but that first hearing is to go over the pleadings. When I say the pleadings, it's this notice to appear. Do you admit this allegation? Do you deny it? Or do you possibly have some status and maybe the asylum officer hasn't noticed it? Do you want to terminate it because there was a mistake? Do you want the government to meet its burden of proving that you are removable? Uh, are you trying to designate a country of removability? And then also, do you want to ask for certain relief from deportation? So, for example, if you've already been referred from an asylum office, you might explain that I want to ask for asylum again. And so, some people see this referral from the asylum office as a full blown denial. It could be seen in many ways, but what you do need to remember is that you now have the opportunity to present your case to the immigration judge. And that they're still locking in that initial date. So I'm just giving you an example. Let's say you came in 10 years ago and you applied for asylum on a timely basis. So that initial asylum application that the asylum officer has decided to refer is still locked in for that date. So you still meet the 1 year requirement and you could present your case now to this immigration judge. Something else that you need to make sure that you understand is that you do have the opportunity to present additional evidence. If you've gained additional evidence, if there's updated articles and evidence that you've had since the asylum interview. But there's a different type of package. There are different requirements than in the asylum office. Now that you're in immigration court, there is a manual that needs to be followed. And also, you want to think of, are there other things that I want to apply for, right? Let's say you already know asylum, withholding of removal, and CAT is what you want to apply for. Is there possibly cancellation of removal as a non LPR? So, what that might be is that you have a US citizen child and you want to explain the hardship that your child would experience if you're removed to your country of nationality. There's certain requirements that have to be met, so not everyone is eligible, but you want to look into, are there different forms of relief other than asylum that you might be eligible for? Okay. One of the main things that you need to keep in mind, for example, for the cancellation of removal for non LPR, is 10 years is generally a requirement for your presence here in the United States. So each category, each form of relief has different requirements. In my firm, we're able to assist if you have been referred and you're looking for an immigration attorney. That's one of the main three areas that we are able to assist with. As a former asylum officer, I like to use my experience to present a very strong asylum application, to think of some of the weaknesses that may have been presented and in the asylum office and think of ways to make it stronger. Also, we attend the master hearing with you and the individual hearing. We support you throughout the way, prepare you to be ready to answer questions for that individual hearing that will happen at a later date. And we just support you throughout the process and we represent you throughout the process. So, in updating that application and sending the pleadings and attending the hearings, we're able to support you with that. So, any other questions, you're welcome to schedule a consultation with me. That's generally the best way to discuss your case with me or to seek representation. My office number is 832-304-5319. Again, it's 832-304-5319. And you can call that number and schedule a consultation. You could also go on my website to schedule directly at marronglaw.com, and that's marronglaw.com. So marronglaw.com. Thank you for listening, and I hope this information was helpful.